All right, the court is calling 2016 CR 5076, State versus Eleanor Arzola. Can I have parties announce?
Rick Boehner for the state of Texas.
John Pettis for defense.
And are you Miss Arzola?
Yes.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Eleanor Arzola who was placed on deferred adjudication in 2016 CR 5076 for the offense of burglary of a habitation on August the 22nd, 2017 for a period of 3 years and extended for a total of 6 years? Is that you?
Okay, pause right here. This is a bombshell opening to the case. What the judge just did was establish Eleanor's criminal history. Burglary of a habitation, a very serious felony in Texas. She was originally given deferred adjudication, which is like probation with a chance to keep a clean record if she stays out of trouble. But here's the kicker. Today's hearing isn't about what happened back in 2017. It's about whether Eleanor violated the rules of her probation. If she admits to even one violation, she could lose her deal and face up to 20 years behind bars. That's the high-stakes gamble she's walking into right now. My question for you, if you were in Eleanor's shoes, would you roll the dice and plead true, or would you fight it out in trial?
Yes.
All right, state.
Yes, Your Honor, we're here this morning on state's motion to enter adjudication of guilt and revoke community supervision. Violation condition number 46. On or about the 7th day of August, 2025, in Bexar County, Texas, the defendant, Eleanor Arzola, did then and there fail to comply with biweekly urinalysis on IVR line in violation condition number 46.
How do you plead to that? True or not true?
The state will waive the other violation.
Any objections?
No objection, Judge.
Did you understand by pleading true to violation of condition number 46, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes.
Knowing that, do you still wish to plead true to violation of condition 46?
And there it is. Eleanor just pleaded true to violating her probation. In simple terms, that's an admission of guilt. This is huge because by saying true, she gives up her chance to argue that she didn't break the rules. Notice the judge carefully explained she could face 20 years. That's not just legal jargon. It's the system reminding her of the maximum risk. But the defense has already worked out a deal. 2 years. Compare that to 20. It almost sounds like mercy, right? But here's the twist. The state can still bring up her other probation history, and the judge can raise the sentence higher than the deal if they choose. What do you think? Should Eleanor get credit for her progress in programs? Or does this violation outweigh everything?
Yes.
Court will find violation of condition number 46 true. Is there a proposed agreement?
There is, Judge.
And what is the request?
Their agreement is to revoke her probation, adjudicate her guilty, sentence her to 2 years TDC.
All right, has she done anything on probation? Other than just being on probation?
She went to my office with that. She's completed patterns intervention. She's completed a significant amount, Judge. Addiction just got hold.
Yeah. Probation?
She had been felony drug court for a little while.
Mm-hmm.
It completed within 23 days of my off. She did an outpatient program as well, VIPP, or parenting class. Oh, I'm sorry. The VIPP, it says there was a violation of program or services, but the MyOff was complete. There's some classes but complete. It was on the GPS for a while. That needs to be complete as well. Total credit of $129 for her assessed fees of $5,154.
All right. The court is going to grant the motion. The court will sentence you to 4 years in the prison, give you credit for any time served.
This is the gut punch moment. The defense and prosecution both asked for 2 years, but the judge went higher, 4 years in state prison. Why? Judges often weigh not just the violation, but the overall compliance history. Eleanor did complete programs like outpatient treatment and parenting classes, but she also failed drug testing and other probation conditions. To the court, it looked like a pattern of partial effort but continued risk. The credit for time served helps, but it's still double what her lawyer tried to negotiate. This is a powerful reminder that judges are not bound by deals. They hold the final hammer. So here's my challenge to you. If you were the judge, would you stick to the deal or send a stronger message with extra time?
Credit for any time served and successful completion of inpatient treatment. So if she was placed in the facilities and she successfully completed those, she'll have credit for those. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Yes. Oh, yes. All right. Because I found you guilty and because I revoked your deferred adjudication, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Do you understand? And I'm going to also request a therapeutic community for you. I can request it for you, but you're going to have to request it as well because I do not have the authority to force them to place you in that program. Once you're released from the prison, if you can't find a sober support house or anything of that nature, just let me know and come back here and I'll pick up the phone and call someone to see if we can get you help. All right? Thank you. All right. Yes. Yes.
Please.
Anthony Lee Warren.
Lee is your middle name?
Yeah.
All right, sir. Do you have a physical residence?
No, due to the Louis fact, you know, the people are not very nice in society.
Okay, so you don't have a residence?
No, I don't know how to go on with them, no.
Okay. Do you have an email address?
Yeah, it's my wallet.
Okay.
I don't have that this time.
Okay. How about a phone number?
No, I mean, email address is Wolverine, loveheart at gmail.com. I think that's what it is.
Okay, well, we'll just hold off. I don't want to go with the possibility. We'll just wait till you get ability to report it to us. The state's alleging 2 charges against you. One of them is disorderly conduct. That's a misdemeanor violation. The second charge is aggravated assault to law enforcement officer. That is a felony charge. On both of those charges, you have the right to remain silent, right to counsel, and right to trial. On the misdemeanor, I've scheduled you for an arraignment on the 20th of August at 1:15 p.m. On the felony, that's scheduled for the 22nd at 4 o'clock p.m., and that's for a preliminary hearing. I'll explain to you the process for the arraignment first, which is dealing with the misdemeanor. That's where you'll need to be prepared to plead either guilty, not guilty, or no contest to disorderly conduct. Depending on how you plead will be what happens next with the court proceeding. All of those options, plus the penalty range, will be explained to you at that hearing. Your release conditions on that and the felony are obey all orders of the court, do not commit any crimes, notify the court immediately of any address change, do not leave the state of Arizona without permission of the court, do not contact the alleged victim in any manner, and then do not go near the location of the alleged offense. Regarding the felony, that aggravated assault charge, the preliminary hearing is to determine if there's probable cause to charge you with that felony, not convict you, only to charge you. If probable cause is found, your case will bind over to the Gila County Superior Court. They'll take disposition on the case.
Now things take a sharp turn. A different defendant, a different case, but the stakes are just as intense. Disorderly conduct may sound minor, but aggravated assault against a law enforcement officer is no joke. That's a felony with potentially devastating consequences. And yet, listen to how casually the defendant responds later, even saying he wants the FBI to investigate his life. This is courtroom drama at its rawest. One person facing serious charges, yet spiraling into personal grievances instead of addressing the case. It raises an important question. How much of this is legal defense, and how much is personal struggle with mental health? Would you see this as someone trying to dodge accountability, or someone genuinely in crisis?
Your release conditions on that are the same release conditions on the prior, but also not to possess any firearms, because that's a felony allegation. If you're convicted, you could become a prohibited possessor. Also, do not contact the alleged victim unless it's for lawful law enforcement purposes only. On each of those charges, there's a $500 bond I'm placing, and then on the misdemeanor disorderly conduct, so a total of $1,000 to bond out. Otherwise, we'll see you on the next court date. Do you have any questions, sir?
Yeah, I'd like to get talk to the FBI about 35 years of things that have been difficult in my life, and I refuse to leave jail, and I don't want to leave jail. I want to be able to stay here until either the FBI can determine everything that's gone wrong in my life, and kind of on my mistakes and also other people's intentions, or if they can determine whether I should be found guilty of all of the charges, or some of them. And the charge that I am found guilty on, I'd rather go to prison. Society is getting me in trouble and bullying my PTSD outside to push me into trouble, to be very negative, and then telling me that I can't get negative. I know that self-defense outside, so
Okay.
I want to be released from jail. I want to stay here until FBI visits me in the jail, please. Can I have that request?
Yeah, we're holding you in custody on those small bonds that I've placed, so you're getting what you're asking for. The other thing is, if you want to call the FBI, just let the detention staff know that you'd like to make a phone call, and at their convenience, they'll give you the phone, and you can make the calls to the FBI how you see fit.
I have a number on my wallet. I'll push for they're okay with that. We'll work it out. It's all work it out. It's all good. Thank you, Honor, and God bless you, sir.
Thank you. Have a good day.
Yes, sir. Thank you, Judge.
You bet. We'll get it sent over shortly. I got to do the 3 in globe, and then I'll do it.
And with that, both cases wrap in very different ways. Eleanor's probation violation led to 4 years behind bars, proof that deferred adjudication is a second chance, but not a free pass. The second defendant now faces both misdemeanor and felony charges, showing how quickly a case can escalate when law enforcement is involved. At the heart of both stories is one lesson. The courtroom is unforgiving, and every decision carries lasting consequences. But now we want to hear from you. Was justice served in Eleanor's sentencing? And what do you make of the second defendant's request to bring in the FBI? Drop your thoughts in the comments. And if you found this breakdown as eye-opening as we did, hit that like button, share this video, and don't forget to subscribe for more shocking courtroom showdowns.